managers strongly support the amendment to issue subpoena for documents to the State Department. As we explain, the first article of impeachment charges the president with using the power of his office to solicit and pressure Ukraine to announce investigations that everyone in this chamber knows to be bogus. The president didn't even care if an investigation was actually conducted, just that it was announced. Why? Because this was for his own personal and political benefit. The first article further charges that the president did so with corrupt motives and that his use of power for personal gain harmed the national security of the United States. As the second article of impeachment charges, the president sought to conceal evidence of this conduct. He did so by ordering his entire administration, every office, every agency, every official to defy every subpoena served in the House impeachment inquiry. No president in history has ever done anything like this. Many presidents have expressly acknowledged that they couldn't do anything like this. President Trump did not take these extreme steps to hide evidence of his innocence or to protect the institution of the presidency. As a career law enforcement officer, I have never seen anyone take such extreme steps to hide evidence allegedly proving his innocence. And I do not find that here today. The president is engaged in this cover up because he is guilty and he knows it. And he knows that the evidence he is concealing will only further demonstrate his culpability. Notwithstanding this effort to stonewall our inquiry, the House amassed powerful evidence of the president's high crimes and misdemeanors. 17 witnesses, 130 hours of testimony combined with the president's own admissions on phone calls and in public comments, confirmed and corroborated by hundreds of texts, emails, and documents. Much of that evidence came from patriotic, nonpartisan, decorated officials in the State Department. They are brave men and women who honored their obligations under the law and gave testimony required by congressional subpoena in the face of the president's taunts and insults. These officials described the president's campaign to induce and pressure Ukraine to announce political investigations, his use of $391 million of vital military aid, taxpayer money appropriated on a bipartisan basis by Congress as leverage to force Ukraine to comply, and his withholding of a meeting desperately sought by the newly elected president of Ukraine. This testimony was particularly compelling because the State Department is at the very center of President Trump's wrongdoing. We heard firsthand from diplomatic officials who saw up close and personal what was happening and who immediately sounded the alarms. Ambassador William Taylor, who returned to Ukraine in June of last year as acting ambassador, texted other State Department officials. I think it's crazy to withhold security assistance for help with a political campaign. Ambassador to the European Union, Gordon Sondland, who was delegated authority over Ukraine matters by none other than President Trump, testified, "We knew these investigations were important to the president, and we followed the president's orders." And David Holmes, a senior official at the U.S. Embassy in Kyiv, said it was made clear that some action on a Burisma Biden investigation was a condition for an Oval Office meeting. During their testimony, many of these State Department officials described specific documents, including text messages, emails, former diplomatic cables, and notes that would corroborate their testimony and shed additional light on President Trump's corrupt scheme. For instance, Ambassador Taylor, who raised concerns that military aid had been conditioned on the president's demand for political investigations, described a little notebook in which he would take notes on conversations he had with key officials. Ambassador Sondland referred by date and recipient to emails regarding the president's demand that Ukraine announce political investigations. As we'll see through emails that were sent to some of President Trump's top advisors, including acting White House Chief of Staff Mick Mulvaney, Secretary of State Michael Pompeo, and Secretary of Energy Rick Perry. Deputy Assistant Secretary of State George Kent, who oversaw Ukraine policy matters in Washington for the State Department, wrote at least 4 memos to file to document concerning conduct he witnessed or heard. And Ambassador Kurt Volker, the special representative for Ukraine negotiations, provided evidence that he and other American officials communicated with high-level Ukrainian officials, including President Zelensky himself, via text message and WhatsApp, about the president's improper demands and how Ukrainian officials would respond to them. Based on the testimony we received and on evidence that has since emerged, all of these documents and others that we will describe bear directly on the allegations set forth in the first article of impeachment. They would help complete our understanding of how the president's scheme unfolded in real time. They would support the conclusion that senior Ukrainian officials understood the corrupt nature of President Trump's demand, and they would further expose the extent to which Secretary Pompeo, acting Chief of Staff Mick Mulvaney, and other senior Trump administration officials were aware of the president's plot and helped carry it out. We're not talking about a burdensome number of documents. We're talking about a specific, discrete set of materials held by the State Department. Documents the State Department has already collected in response to our subpoena, but has never produced. We know these materials exist. We know they are relevant, and we know the president is desperately trying to conceal them. As I will describe, the Senate should subpoena the following. Number 1, WhatsApp and other text message communications. 2, emails. 3, diplomatic cables. And 4, notes. Given the significance and relevance of these documents, the House requested that they be provided. When these requests were denied, the House issued subpoenas commanding that the documents be turned
Are you a
over.
dummy dumbass? Or are you a dummy
But at the
dumbass?
president's
Simple enough question.
direction,
Simple enough question. Simple.
the Department of State unlawfully defied that subpoena. And I stand here now.
With my pen.
As I stand here now, the State Department has all these documents in its possession, but refuses, based on the president's order, to let them see the light of day. This is an affront
To the
to the House,
districtification.
which has full power to see these documents. It is an affront to the Senate, which has been denied a full record on which to judge the president's guilt or innocence, and it is an affront to the
Whoops, shouldn't have been
Constitution,
talking in the background.
which makes clearly that nobody, not even the president, is above the law.
The law.
And it is an affront to the American people, who have a right to know what the president and his allies are hiding from them and why it is being hidden. In prior impeachment trials, this body has issued subpoenas requiring the recipient to hand over relevant documents. It must do so again here. And it must do so now at the beginning of the trial, not the end. Of course, the need for a Senate subpoena arises because, as I've noted, the president ordered the State Department to defy a subpoena from the House. At this point, I'd like to briefly describe our own efforts to get those materials. I'll then address in a more detailed fashion exactly what documents the State Department has hidden from the American people and why the Senate should require it to turn them over. On September 9th, exercising their Article 1 oversight authority, the House Investigating Committee sent a document request to the State Department. The committee sought materials related to the president's effort to pressure Ukraine to announce investigations into his political rival, as well as his dangerous, unexplained withholding of millions of dollars in vital military aid. After the State Department failed to produce any documents, the House Committee on Foreign Affairs issued a subpoena to the State Department on September 27th. A letter on October 3rd, Secretary Pompeo acknowledged receipt of the subpoena. At that time, he stated that he would respond to the committee's subpoena for documents by the return date, October 4th. But his response never came. Instead, on October 8th, President Trump's lawyer, writing on the president's behalf, issued a direction confirming that the administration would stonewall the impeachment inquiry. To date, the State Department has not produced a single document, not a single document in response to the congressional subpoena. But witnesses who testified indicated that the State Department had gathered all of the records and was prepared to provide them before the White House directed it to defy the subpoena. Notwithstanding this unlawful obstruction through the testimony of brave State Department employees, the House was able to identify with remarkable precision several categories of documents relevant to the first article of impeachment that are sitting right now. Right now, those documents are sitting right now at the State Department. I'd like to walk you through 4 key categories of documents that should be subpoenaed and which illustrate the highly relevant documents the State Department could produce immediately. They could produce them immediately for this trial. The first category consists of WhatsApps and other text messages from State Department officials caught up in these events, including Ambassadors Sondland and Taylor, and also Deputy Assistant Secretary George Kent, all 3 of whom confirmed in their testimony that they regularly use WhatsApp to communicate with each other and foreign government officials. As Deputy Assistant Secretary Kent explained, WhatsApp is a dominant form of electronic communication in certain parts of the world. We know that the State Department possesses the records of WhatsApp and text messages from critical eyewitnesses to these proceedings, including from Ambassadors Sondland and Taylor and Deputy Assistant Secretary Kent. We know that the department is deliberately deliberately concealing these records at the direction of the president, and we know that they could contain highly relevant testimony about the president's plan to condition official presidential acts on the announcements of investigations for his own personal and political gain. We know this not only from testimony, but also because Ambassador Volker was able to provide us with a small but telling selection of his WhatsApp messages. Those records confirm with a full review of these texts and WhatsApp messages from relevant officials would help to paint a vivid firsthand picture of statements, decisions, concerns, and beliefs held by important players of events unfolding in real time. For example, thanks to Ambassador Volker's messages, we know that Ambassador Sondland, a key player in the president's pressure campaign, who testified in the House about a quid pro quo arrangement, texts directly with the Ukrainian president, President Zelensky. This image, produced by Ambassador Volker, appears to be a screenshot of a text message that Ambassador Sondland exchanged with President Zelensky about plans for the White House visit, the very same visit that President Zelensky badly needed, and that President Trump later withheld as part of the quid pro quo described by Ambassador Sondland in his testimony. This body and the American people have a right to know what else Ambassador Sondland and President Zelensky said in this and other relevant exchanges about the White House meeting or about the military aid and the president's demand. But we don't know exactly what was conveyed and when. We don't know if President Trump directed the State Department to conceal these vital records. These are records that the State Department would have otherwise turned over, if not for the president's direction and desire to cover up his wrongdoing. To get a sense of why texts and WhatsApp messages are so vital, just consider whether another piece of evidence we gleaned from Ambassador Volker's partial production. On July 10th, at the White House meetings, at which Ambassador Sondland pressured Ukrainian officials to announce investigations of President Trump's political opponents, a Ukrainian governmental official texted Ambassador Volker, "I feel that the key for many things is Rudy, and I am ready to talk with him at any time." This is evidence that immediately following Ambassador Sondland's ultimatum, Ukrainian officials recognized that they needed to appease Rudy Giuliani by carrying out the investigations. Of course, Mr. Giuliani had publicly confirmed that he was not engaged in foreign policy, but it was instead advancing his clients, the president's own personal interest. Further, in another text message exchange provided by Ambassador Volker, we see evidence that Ukraine understood President Trump's demands loud and clear. On the morning of July 25th, half an hour before the infamous call between President Trump and President Zelensky, Ambassador Volker wrote to a senior Ukrainian official heard from White House. Assuming President Z convinces Trump he will investigate, get to the bottom of what happened in 2016, we will nail down date for visit to Washington. Good luck. See you tomorrow. Kurt. Ambassador Sondland confirmed that this text accurately summarized the president's directive to him earlier that morning. After the phone call between President Trump and President Zelensky, the Ukrainian official responded pointedly, "Phone call went well." He then discussed potential dates for a White House meeting. Then the very next day, Ambassador Volker wrote to Rudy Giuliani, exactly the right messages as we discussed. These messages confirm Mr. Giuliani's central role, the premeditated nature of President Trump's solicitation of political investigation, and the pressure campaign on Ukraine waged by Mr. Giuliani and senior officials at President Trump's direction. Again, this is just some of what we learned from Ambassador Volker's records. As you will see during this trial presentation, there were numerous WhatsApp messages in August, while Ambassadors Volker and Sondland and Mr. Giuliani were pressuring President Zelensky's top aide to issue a statement announcing the investigations that President Trump wanted. And Ambassador Taylor's text that you saw earlier about withholding the aid further reveals how much more material there likely is that relates to the articles of impeachment. There can be no doubt that a full production of relevant text and WhatsApp messages from other officials involved in Ukraine and in touch with Ukrainian officials, including Ambassador Sondland, Ambassador Taylor, and Deputy Assistant Secretary Kent, would further illuminate the malfeasance addressed in our first article. This leads to the second category of documents that the State Department is unlawfully withholding: emails involving key State Department officials concerning interactions with senior Ukrainian officials and related to military aid, a White House meeting, and the president's demand for investigations into his rivals. For example, on July 19th, Ambassador Gordon Sondland spoke directly with President Zelensky about the upcoming July 25th call between President Trump and President Zelensky. Ambassador Sondland then sent an email updating key officials about Secretary Pompeo, including Secretary Pompeo, acting White House Chief of Staff Mulvaney, and his senior advisor, Robert Blair. In this email, he noted that he prepared President Zelensky, who was willing to make the announcements of political investigations that President Trump desired. Secretary Perry and Mick Mulvaney then responded to Sondland, acknowledging they received the email and recommending to move forward with the phone call that became the July 25 call between the presidents of the United States and Ukraine. We know all of this not because the State Department provided us with critical document, but instead because Ambassador Sondland provided us a reproduction of the email. In his public testimony, Ambassador Sondland quite correctly explained that this email demonstrated, quote, everyone was in the loop.
Everyone was in the loop. It was no secret. Everyone was informed via email on July 19th, days before the presidential call. As I communicated to the team, I told President Zelensky in advance that assurances to run a fully transparent investigation and turn over every stone were necessary in his call with President Trump.
Even viewed alone, this reproduced email is damning. It was sent shortly after Ambassador Sondland personally conveyed the president's demand for investigations to Ukrainians at the White House, leading several officials to sound alarms. It was sent just a few days before the July 25 call, where President Trump asked for a favor. And by itself, this email shows who was embroiled in President Trump's plan to pressure the Ukrainian president for his own political gain. But it's obvious that the full email chain and other related emails to this key time period would also be highly relevant. We don't have those emails because the State Department is hiding them at the direction of the president. The Senate should issue the proposed subpoena to ensure a complete record of these and other relevant emails. Any doubt that the State Department is concealing critical evidence from this body was resolved when the State Department was recently ordered to release documents, including emails pursuant to a lawsuit under the Freedom of Information Act. These documents are heavily redacted and are limited to a very narrow time period. But nevertheless, despite the heavy redactions, these highly limited glimpse into the State Department's secret record demonstrates that those records are full of information relevant to this trial. For example, several of these newly elected or released emails show multiple contacts between the State Department, including Secretary Pompeo and Mr. Giuliani throughout 2019. This is an important fact. Mr. Giuliani served as the president's point person in executing his corrupt scheme. Mr. Giuliani repeatedly emphasized that his role was to advance the president's personal agenda. The president's political interests, not to promote the national security interests of the United States. The fact that the president's private attorney was in contact at key junctures with the Secretary of State, whose senior officials were directed by the president to support Mr. Giuliani's efforts in Ukraine, is relevant, disturbing, and telling. For example, we know that on March 26th, as Mr. Giuliani was pursuing the president's private agenda in Ukraine, and just 1 week after the Hill published an article featuring Mr. Giuliani's Ukraine conspiracy theories, Secretary Pompeo and Mr. Giuliani spoke directly on the phone. That same week, President Trump's former personal secretary was asked by Mr. Giuliani's assistant for a direct connection to Secretary Pompeo. Based on these records, it is also clear that Secretary Pompeo was already actively engaged with Mr. Giuliani in early spring of 2019. And it also appears that these efforts were backed by the White House, given the involvement of President Trump's personal secretary. This body and the American people need to see these emails and other files at the State Department, fleshing out these exchanges and the details surrounding Mr. Giuliani's communications with Secretary Pompeo. Moreover, based on call records lawfully obtained by the House from this period, we know that from March 24th to March 30th, Mr. Giuliani called the White House several times and also connected with an unidentified number numerous times. These records show that on March 27th, Mr. Giuliani placed a series of calls to the State Department switchboard, Secretary Pompeo's assistant, and the White House switchboard in quick succession, all within less than 30 minutes. Obtaining emails and other documents regarding the State Department's leadership's interaction with President Trump's private lawyer in this period, when Mr. Giuliani was actively orchestrating the pressure campaign in Ukraine related to the sham investigation into Vice President Biden and the 2016 election, would further clarify the president's involvement and direction at this key juncture in the formation of a plot to solicit foreign interference into our election. We also know, based on recently obtained documents, that Les Parmas, an associate of Rudy Giuliani, has assisted him in his representation of President Trump, that Giuliani likely spoke with Secretary Pompeo about Ukraine matters even earlier than previously understood. According to documents obtained from Mr. Parmas, Mr. Giuliani wrote in early February of 2019 that he apparently spoke with Secretary Pompeo about the removal of the U.S. ambassador in Ukraine, Marie Yovanovitch. Mr. Giuliani viewed her as an impediment to implementing the president's corrupt scheme and orchestrated a long-running smear campaign against her. Here's what Mr. Parmas said about this just last week.
You believe that part of the motivation to get rid of Ambassador Yovanovitch, to get her out of post, was because she was in the way of this effort to get the government of Ukraine to announce investigations of Joe Biden?
That was the only motivation.
That was the only motivation.
There was no other motivation.
These are just some of the email communications that we know. These are just some of the email communications that we know to exist, but there are undoubtedly more, including, for example, Ambassador Yovanovitch requests for the State Department to issue a statement of support of her around the time that Mr. Giuliani was speaking directly with Secretary Pompeo. But that statement never came. The State Department has gathered these records and they are ready to be turned over pursuant to a subpoena from the Senate. It would not be a time-consuming or lengthy process to obtain them. And there are clearly important and relevant documents to the president's scheme. If we want the full and complete truth, then we need to see those emails. The Senate should also seek a third item that the State Department has refused to provide, and that's Ambassador Taylor's extraordinary first-person diplomatic cable to Secretary Pompeo dated August 29 and sent at the recommendation of the National Security Advisor, John Bolton, in which Ambassador Taylor strenuously objected to the withholding of military aid from Ukraine, as Ambassador Taylor recounted in his deposition.
Near the end of Ambassador Bolton's visit, I asked to meet him privately, during which I expressed to him my serious concern about the withholding of military assistance to Ukraine while the Ukrainians were defending their country from Russian aggression. Ambassador Bolton recommended that I send a first-person cable to Secretary Pompeo directly, relaying my concerns. I wrote and transmitted such a cable on August 29th, describing the folly I saw in withholding military aid to Ukraine at a time when hostilities were still active in the East and when Russia was watching closely to gauge the level of American support for the Ukrainian government. The Russians, as I said at my deposition, would love to see the humiliation of President Zelensky at the hands of the Americans. I told the Secretary that I could not and would not defend such a policy. Although I received no specific response, I heard that soon thereafter, the Secretary carried the cable with him to a meeting at the White House focused on security assistance for Ukraine.
While we know from Ambassador Taylor and Deputy Assistant Secretary Kent that the cable was received, we do not know whether or how the State Department responded, nor do we know if the State Department possesses any other internal records relating to this cable. This cable is vital for three reasons. First, it demonstrates the harm that President Trump did to our national security when he used foreign policy as an instrument of his own personal political gain. Second, on the same day the cable was sent, President Zelensky's senior aide told Ambassador Taylor that he was very concerned about the hold on military assistance. He added that the Ukrainians were just desperate, added to be released. In other words, President Trump's effort to use military aid to apply additional pressure on Ukraine was working. And finally, based on reporting by the New York Times, we now know that within days of Ambassador Taylor sending this cable, President Trump discussed Ukrainian security assistance with Secretary Pompeo, Defense Secretary Esper, and National Security Advisor Bolton. The investigation uncovered testimony that Secretary Pompeo brought Ambassador Taylor's cable to the White House. Perhaps it was during this meeting. There, perhaps prodded by Ambassador Taylor's cable, all three of them pleaded with the president to resume the crucial military aid. Yet the president refused. This body has a right to see Ambassador Taylor's cable as well as the other State Department records addressing the official response to it. Although it may have been classified at the time, the State Department can no longer claim that the topic of security assistance remains classified today in light of the president's decision to declassify his 2 telephone calls with President Zelensky and Mr. Mulvaney's public statements about security assistance. The fourth category of documents that the Senate should subpoena are contemporaneous first-person accounts from State Department officials who were caught up in President Trump's corrupt scheme. These documents, which were described in detail by Deputy Assistant Secretary Kent, Ambassador Taylor, and political officer David Holmes, would help complete the record and clarify how the president's scheme unfolded in real time and how the Ukrainians reacted. Mr. Kent wrote notes or memos to file at least 4 times, according to his testimony. Ambassador Taylor took extensive notes of nearly every conversation he had, some in a little notebook. And David Holmes, the embassy official in Ukraine, was a consistent note taker of important meetings with Ukrainian officials.
Did you take notes of this conversation on September 1st with Ambassador Sondland?
I did.
And did you take notes related to most of the conversations, if not all of them, that you recited in your opening statement?
All of them, Mr. Goldman.
And you are aware, I presume, that the State Department has not provided those notes to the committee, is that right?
I am aware.
So we don't have the benefit of reviewing them to ask you these questions.
Correct. I understand that they may be coming sooner or later.
Well, we would welcome that.
The State Department never produced those notes. As another example, Deputy Assistant Secretary Kent testified about a key document that he drafted on August 16th, describing his concerns that the Trump administration was attempting to pressure Ukraine into opening politically motivated investigations.
I'd like to start with you, Mr. Kent. In your testimony, you said that you had, in mid-August, it became clear to me that Giuliani's efforts to gin up politically motivated investigations were now infecting U.S. engagement with Ukraine, leveraging President Zelensky's desire for a White House meeting. Mr. Kent, did you actually write a memo documenting your concerns that there was an effort underway to pressure Ukraine to open an investigation to benefit President Trump?
Yes, ma'am. I wrote a memo to the file on August 16th.
But we don't have access to that memo, do we?
I submitted it to the State Department subject to the September 27th subpoena.
And we have not received one piece of paper from the State Department relative to this investigation.
Deputy Assistant Secretary Kent also memorialized a September 15 conversation at which Ambassador Taylor described a Ukrainian official accusing America of hypocrisy for advising President Zelensky against investigating a prior Ukrainian president. Mr. Kent described that conversation during his testimony. He said, but the more awkward part of the conversation came after Special Representative Volker made the point that the Ukrainians, who had opened their authorities under President Zelensky, had opened investigations of former President Poroshenko. He didn't think that was appropriate. And then Andrei Yermak said, what? You mean the type of investigations you're pushing for us to do on Biden and Clinton? The conversation makes clear the Ukrainian officials understood the corrupt nature of President Trump's requests and therefore doubted American credibility on anti-corruption measures. Records of these conversations and other notes and memoranda by senior American officials in Ukraine would flesh out and help complete the record for the first article of impeachment. They would tell the whole truth and to the American people and to this body. You should require the State Department to provide them. To summarize, the Senate should issue the subpoena proposed in the amendment requiring the State Department to turn over relevant texts and WhatsApp messages, emails, diplomatic cables, and notes. These documents bear directly on the trial of this body, the trial that this body is required by the Constitution to hold. They are immediately relevant to the first article of impeachment. Their existence has been attested to by credible witnesses in the House. And the only reason we don't already have them is that the president has ordered his administration, including Secretary Pompeo, to hide them. The president's lawyers may suggest that the House should have sought these materials in court or awaited further lawsuits under the Freedom of Information Act, aka FOIA lawsuits. Any such suggestion is meritless. To start, the Constitution has never been understood to require such lawsuits, which has never occurred. It's never occurred in any previous impeachment. Moreover, the president has repeatedly and strenuously argued that the House is not even allowed to file a suit to enforce its subpoenas. And in the Freedom of Information Act cases, the administration has only grudgingly and slowly produced an extremely small set of materials, but has insisted on applying heavy and dubious redactions. FOIA lawsuits filed by third parties cannot serve as a credible alternative to congressional oversight. In fact, it is still alarming that the administration has produced more documents pursuant to the Federal Office of Information Act lawsuits by private citizens and entities than congressional subpoenas. Finally, as we all know, litigation would take an extremely long time, likely years, not weeks or months, while the misconduct of this president requires immediate attention. The misconduct of this president requires immediate attention if this body is truly committed to a fair trial. It cannot let the president play a game of keep away and dictate what evidence the senators can and cannot see bearing on his guilt or innocence. This body cannot permit him to hide all the evidence while disingenuously insisting on lawsuits that he doesn't actually think we can file, ones that he knows won't be resolved until after the election. He is trying to cheat to win. Instead, to honor your oaths to do impartial justice, we urge each senator to support a subpoena to the State Department. And that subpoena should be issued now at the beginning of the trial rather than at the end, so these documents can be reviewed and their importance weighed by the parties, the Senate, and by the American people. That is how things work in every courtroom in the nation. And it is how they should work here, especially because the stakes, as you all know, are so high. The truth is there. Facts are stubborn things. The president is trying to hide it. This body should not surrender to his obstruction by refusing to demand a full record. That is why the House managers support this amendment. And Mr. Chief Justice, the House managers reserve the balance of our time.
Wow.
Mr. Cipollone?
Here we go. Cipollone, Captain
Thank you,
Rebut.
Mr. Chief Justice.
Come on, butt.
In the
Rebut.
interest of time, I won't repeat all of the arguments that we've made already with respect to these motions. I would say one thing before I turn it over to my
That is that I'm a
co-counsel.
shill.
Mr. Schiff came here and said he's not asking you to do something he wouldn't do for himself. And the House manager said, we're not asking you to do our jobs for us. And Mr. Schiff came up here and he said, I call Ambassador Bolton. Remember Paul Harvey? It's time for the rest of the story. He didn't call him in the House. He didn't subpoena Ambassador Bolton in the House. I have a letter here from Ambassador Bolton's lawyer. He's the same lawyer that Charlie Kupperman hired. It's dated November 8th. He said, I write as counsel to Dr. Charles Kupperman and to Ambassador John Bolton in response to the letter of November 5th from Chairman Schiff, Chairman Engel, and Acting Chair Maloney, the House chairs, withdrawing the subpoena to Dr. Kupperman. I mentioned that earlier. And to recent published reports announcing that the House chairs do not intend to issue a subpoena to Ambassador Bolton. He goes on and says, we are dismayed that the committees have chosen not to join us in seeking resolution from the judicial branch of this momentous constitutional question. And he ends the letter by saying, if the House chooses not to pursue through subpoena the testimony of Dr. Kupperman and Ambassador Bolton, let the record be clear. That is the House's decision. And they made that decision. They never subpoenaed Ambassador Bolton. They didn't try to call him in the House. And they withdrew the subpoena for Charles Kupperman before the judge could rule, and they asked that the case be mooted. And now they come here and they ask you to issue a subpoena for John Bolton. It's not right. I yield the remainder of my time to Mr. Sekulow.
Mr. Chief Justice, members of the Senate, the manager said facts are a stubborn thing. Let me give you some facts. It's from the transcripts. Ambassador Sondland actually testified unequivocally that the president did not tie aid to investigations. Instead, that he acknowledged any leak he had suggested was based entirely on his own speculation, unconnected to any conversation with the president. Here's the question. What about the aid? Ambassador Volker says that they were tied, that the aid was not tied. Answer. I didn't say that they were conclusively tied either. I said I was presuming it. Question. Okay. And so the president never told you they were tied. Answer. That is correct. Question. So your testimony and Ambassador Volker's testimony is consistent. And the president did not tie investigations, aid to investigations. Answer. That is correct. Ambassador Sondland also testified that he asked President Trump directly about these issues. The president explicitly told him that he did not want anything from Ukraine. I want nothing. I want nothing. I want no quid pro quo. Tell Zelensky to do the right thing. Similar comments were made to Senator Johnson. Those are the facts. Stubborn. That's the facts. No one is above the law. Here's the law. As every member of Congress knows, undoubtedly aware, separate from even state secret privileges is the presidential communication executive privilege to communications and performance of a president's responsibilities. The presidential communication privilege has constitutional origins. Courts have recognized a great public interest in preserving the confidentiality of conversations that take place in the president's performance of his official duties, because such confidentiality is needed to protect the effectiveness of the executive decision-making process. In Ray Seal cases, that was decided in the District of Columbia Court of Appeals. The Supreme Court found such a privilege necessary to guarantee the candor of presidential advisors and to provide a president and those who assist him with freedom to explore alternatives in the process of ultimately shaping policies and making decisions, and to do so in a way many would be unwilling to express except in private. For these reasons, presidential conversations are presumptively privileged. There's something else about this privilege. Communications made by presidential advisors, again, quoting courts. And by the way, lawyer lawsuits? We're talking about the impeachment of a president of the United States, duly elected. And the managers are complaining about lawyer lawsuits? The Constitution allows lawyer lawsuits. It's disrespecting the Constitution of the United States to even say that in this chamber. Lawyer lawsuits. Here's the law. Communications made by presidential advisors in the course of preparing advice for the president come under the presidential communications privilege, even when these communications are not made directly to the president. Even when they're not made directly to the president, advisor to advisor. Given the need to provide sufficient elbow room for advisors to obtain information from all knowledgeable sources, the privilege must apply both to communications which these advisors solicit and receive from others, as well as those they authorize themselves. The privilege must also extend to communications authored or received in response to solicitation by members of a presidential advisor staff, since in many instances, advisors must rely on their staffs to investigate and issue and formulate advice given to the president. Lawsuits. The Constitution. A dangerous moment for America when an impeachment of a president of the United States is being rushed through because of lawyer lawsuits. The Constitution allows it if necessary. The Constitution demands it if necessary. Thank you, Mr. Chief Justice.
Mrs. Stebbings, you have 13 minutes for rebuttal. Mr. Schiff.
Thank you, Mr. Chief Justice. Let me just respond to some of my colleagues' points, if I can. First, counsel said, well, the House would like to call John Bolton, but the House did not seek his testimony during its investigation. Well, first of all, we did. We invited John Bolton to testify, and you know what he told us? I'm not coming, and if you subpoena me, I will sue you. That was his answer. I will sue you. Mr. Bolton is represented by the same lawyer who represents Dr. Kupperman, who actually did sue us when he was subpoenaed. So we knew that John Bolton would make good on that threat. Now, Mr. Sekulow says something about lawyer lawsuits. Now, I have to confess I wasn't completely following the argument, but something about lawyer lawsuits, that we're against lawyer lawsuits. Well, I don't know what that means, but I can tell you this. The Trump Justice Department is in court in that case and other cases arguing Congress cannot go to court to enforce its subpoenas. So when they say something about lawyer lawsuits and they say there's nothing wrong with the House suing to get these witnesses to show up, and they should have sued to get them to show up, their own other lawyers are in court saying the House has no such right. They're in court saying you can't have lawyer lawsuits. So that argument cannot be made in both directions. What's more, in the Kupperman litigation, in the McGahn litigation, which tested the same bogus theory of absolute immunity. In that lawsuit, once again involving the president's lawyer, Don McGahn, the one who was told to fire the special counsel and then to lie about it, that lawsuit, to get his testimony. Judge Jackson ruled on that very recently when they made the same bogus claim. He's absolutely immune from showing up. And the judge says that's nonsense. There's no support for that, none in the Constitution, none in the case law, that is made out of whole cloth. But you know, the judge said something more that was very interesting. Because what we urged John Bolton's lawyer is, you don't need to file a lawsuit. Dr. Kupperman, you don't need to file a lawsuit. There's one already filed involving Don McGahn that's about to be decided. So unless your real purpose here is delay, unless your real purpose here is to avoid testimony and you just wish to give the impression of a willingness to come forward, you just want to have the court's blessing, if that's really true, agree to be bound by the McGahn decision. Well, of course they were not willing, because they didn't want to testify. Now, for whatever reason, John Bolton is now willing to testify. I don't know why that is. Maybe it's because he has a book coming out. Maybe it's because it will be very hard to explain why he was unwilling to share important information with the Senate, that he couldn't show up for a House deposition or interview because he would need court permission to do it, but he can put it in a book. I don't know. I can't speak to his motivation, but I can tell you he's willing to come now, if you're willing to hear him. But of course, they weren't willing to be bound by that court decision in McGahn, but the court said something very interesting, because one of the arguments they had been making, one of the arguments that John Bolton's lawyer had been making as to why they needed their own separate litigation was, well, John Bolton and Dr. Kupperman, they're national security people, and Don McGahn is just the White House counsel. No offense to the White House counsel, but apparently you have nothing to do with national security. And so they couldn't be bound by what the court in the McGahn case said. Well, the judge in the McGahn case said, this applies to national security stuff too. So we do have a court decision, and what's more, we have the court decision in the Harriet Miers case in the George W. Bush administration, where likewise the court made short shrift of this claim of absolute, complete, and total immunity. Now, there were also comments made about Ambassador Volker's testimony by Mr. Sekulow, and it was along these lines. Master Volker said the president never told him that the aid was being conditioned, or the meeting was being conditioned on Ukraine doing these sham investigations. So, well, I guess that's case closed. Unless the president told everyone, called them into their office and said, hey, I'm going to tell you now, and then I'm going to tell you now. If he didn't tell everyone, I guess it's case closed. Well, you know who the president did tell, among others? He told Mick Mulvaney. Mick Mulvaney went out on national television and said, yes, they discussed it. This investigation, this Russian narrative that it wasn't Ukraine that intervened in 2016, it was Russia. I'm sorry, it wasn't Russia, it was Ukraine. Yes, that bogus 2016 theory, yes, they discussed it. Yes, that was part of the reason why they withheld the money. And when reporters said, well, you're kind of describing a quid pro quo, his answer was, yeah, get used to it or get over it. We do it all the time. Now, they haven't said they want to hear from Mick Mulvaney. I wonder why. The president did talk to Mick Mulvaney about it. Wouldn't you like to hear what Mick Mulvaney has to say? I mean, if you really want to get to the bottom of this, if they're really challenging the fact that the president conditioned $400 million of military aid to an ally at war, if Mick Mulvaney has already said publicly that he talked to the president about it, and this is part of the reason why, don't you think you should hear from him? Don't you think impartial justice requires you to hear from him? Now, counsel also referred to Ambassador Sondland, and Sondland saying, well, the president told me there was no quid pro quo. Now, of course, at the time the president said to Sondland, no quid pro quo, he became aware of the whistleblower complaint, presumably by Mr. Cipollone. And so the president knew that this was going to come to light on the advice, apparently, of Mr. Cipollone, or maybe others. The Director of National Intelligence, for the first time in history, withheld a whistleblower complaint from Congress, its intended recipient. But nonetheless, the White House was aware of that complaint. We launched our own investigations. Yes, they got caught. And in the midst of being caught, what does he say? It's called a false exculpatory. For those people at home, that's a fancy word of saying it's a false, phony alibi. No quid pro quo. He wasn't even asked the question, was there a quid pro quo? He just blurted it out. That's the defense, that the president denies it. And what's more interestingly, he didn't tell you about the other half of that conversation where the president says no quid pro quo. He says no quid pro quo. But Zelensky needs to go to the mic. And he should want to do it. Which is the equivalent of saying no quid pro quo except the quid pro quo. And here's what the quid pro quo is. He needs to go to the mic and he should want to do it. That's their alibi. They didn't also mention, of course, and you'll hear about this during the trial if we have a real trial. Ambassador Sondland also said that we're often asked, was there a quid pro quo? The answer is yes, there was a quid pro quo. There was an absolute quid pro quo. And what's more, when it came to the military aid, it was as simple as 2 + 2. Well, I'll tell you something. We're not the only people who can add up 2 + 2. There are millions of people watching this can add up 2 + 2 also. When the president tells his chief of staff we're holding up the aid because of this, as the chief of staff admitted, when the president gives no plausible or other explanation for holding up aid that you all, chief of staff, admitted, when the president gives no plausible or other explanation for holding up aid that you all and we all supported and voted on a very bipartisan way, has no explanation for it. When in that call, he never brings up corruption except the corruption he wants to bring about. It doesn't take a genius. It doesn't take Albert Einstein to add 2 + 2. It equals 4. In this case, it equals guilt. Now, you're going to have 16 hours to ask questions. You're going to have 16 hours. That's a long time to ask questions. Wouldn't you like to be able to ask about the documents in that 16 hours? Would you like to be able to say, counsel for the president, what did Mick Mulvaney mean when he emailed so-and-so and said such and such? What's your explanation for that? Because that seems to be pretty damning evidence of exactly what the House is saying here. What's your explanation of that, Mr. Sekulow? What's your explanation? Wouldn't you like to be able to ask about the documents? Or ask the House, Mr. Schiff, what about this text message? Doesn't that suggest such as what the president is arguing? Wouldn't you like to be able to ask me that question or my colleagues? I think you would. I think you should. But the backwards way this resolution is drafted, you get 16 hours to ask questions about documents you've never seen. And then you know what's more? If you do decide at that point after the trial is essentially over that you do want to see the documents after all, and the documents are produced, you don't get another 16 hours. You don't get 16 minutes. You don't get 16 seconds to ask about those documents. Does that make any sense to you? Does that make any sense at all? I'll tell you something I'd like to know. that may be in the documents. You probably heard more about the three amigos. My colleagues mentioned two of the three amigos, Amigo Volker and Amigo Sondland. These are two of the three people that the president put in charge of Ukraine policy. The third amigo is Secretary Rick Perry, the former Secretary of Energy. But we know from Amigo Sondland's testimony that he was certainly in the loop. He knew exactly all about this scheme. And we know from Ambassador Volker's testimony and his text messages and his WhatsApps that amigo was in the loop. What about the third amigo? Wouldn't you like to know if the third amigo was in the loop? Now, as my colleagues will explain, and when we get to the Department of Energy records, that, well, surprisingly, we didn't get those either. But any communication between the Department of Energy and the Department of State is covered by this amendment. Wouldn't you like to know? Don't you think the American people have a right to know what the third amigo knew about this scheme? I'd like to know. I think you should be able to ask questions about it in your 16 hours. At the end of the day, I guess I'll finish with something Mr. Sekulow said. He said, this was a dangerous moment because we're trying to rush through this somehow. It is a dangerous moment, but we're not trying to rush through this trial. We're actually trying to have a real trial here. It's the president that's trying to rush through this. And I have to tell you that whatever you decide here, maybe this is wasted breath and maybe it's already decided, but whatever you decide here, I don't know who the next president's going to be. Maybe it'll be someone in this chamber. But I guarantee you this, whoever that next president is, whether they did something right or they did something wrong, there's going to come a time where you in this body are going to want to subpoena that president and that administration. You're going to want to get to the bottom of serious allegations. Are you prepared to say that that president can simply say, I'm going to fight all subpoenas? Are you prepared to say and accept that president saying, I have absolute immunity. You want me to come testify? Senator, you want me to come and testify? No, I have absolute immunity. You can subpoena me all you like. I'll see you in court. And when you get to court, I'm going to tell you, you can't see me in court. Are you prepared for that? That's what the future looks like. Justice, I yield back. I thank you.
The majority leader is recognized.
To table the amendment.
The question is on the motion to table.
And ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher, Mr. Gardner, Mrs. Gilliram, Mr. Graham, Mr. Grassley, Ms. Harris, Ms. Hassan, Mr. Hawley, Mr. Heinrich, Ms. Hirono, Mr. Hoven, Mrs. Hyde-Smith, Mr. Inhofe, Mr. Johnson, Mr. Jones, Mr. Kane, Mr. Kennedy, Mr. King, Ms. Klobuchar, Mr. Langford, Mr. Leahy, Mr. Lee, Mrs. Leffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Perdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Risch, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
So there you have it, the vote on the second Schumer amendment, which would allow for the presentation of witnesses, of documents from the State Department, of all the relevant materials, so that the senators could have that before starting the trial. The most sensible request there is. The previous request, which may have been, all the way up to the White House and so on, was defeated. It was tabled. The ayes voted to table it 53 to 47. I believe that's exactly party lines. So let's see what happened here with the second of the two amendments. Oh man, look at that. The damn thing stopped again. Pardon my language. Very irritating. Hopefully it'll come back and we won't have an issue.
C-SPAN, your unfiltered view of government, created by cable in 1979.
Come on, buddy. That's amazing. Just when the vote was happening, it stopped for us. So I'm not sure what to do here. Forgive me for the technical difficulty. This is Vote Count 2020. I am Karthik Rajan, and all day today we have covered the impeachment of Donald J. Trump in the Senate by using C-SPAN, the government nonprofit monitoring channel. It started in the days of cable television. And we are attempting to get back the program, but for some reason it's not seeming to come back. Let's try refreshing the page. And hopefully here in a moment we'll see the results. The previous
C-SPAN, your unfiltered view of government, created by cable in 1979.
Vote was
the actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance of any kind to Ukraine, including but not limited to the Ukraine Security Assistance Initiative, referred to in this section as USAI, and foreign military financing, referred to in this section as FMF, including but not limited to: 1, communications among, between, or referring to Director Michael John Mick Mulvaney, Assistant to the President Robert Blair, Acting Director Russell Vaught, Associate Director Michael Duffy, or any other Office of Management and Budget employee. 2, communications related to requests by President Trump for information about Ukraine's security or military assistance and responses to those requests. 3, communications related to concerns raised by any Office of Management and Budget employee related to the legality of any hold on foreign assistance, military assistance, or security assistance to Ukraine. 4, communications sent to the Department of State regarding a hold or block on congressional notifications regarding the release of FMF funds to Ukraine. 5, communications between 1, officials at the Department of Defense, including but not limited to Undersecretary of Defense Elaine McCusker, and 2, Associate Director Michael Duffy, Deputy Associate Director Mark Sandy, or any other Office of Management and Budget employee. 6, all draft and final versions of the August 7th, 2019 memorandum prepared by the National Security Division, International Affairs Division, and Office of General Counsel of the Office of Management and Budget about the release of foreign assistance, security assistance, or security assistance to Ukraine. 7, the Ukrainian government's knowledge prior to August 28th, 2019, of any actual or potential suspension, withholding, delaying, freezing, or releasing of United States foreign assistance, military assistance, or security assistance to Ukraine, including all meetings, calls, or other engagement with Ukrainian officials regarding potential or actual suspensions, holds, or delays in United States assistance to Ukraine. B, communications, opinions, advice, counsel, approvals, or concurrences provided by any employee in the Office of Management and Budget regarding the actual or potential suspension, withholding, delaying, freezing, or releasing of security assistance to Ukraine, including legality under the Impoundment Control Act. C, Associate Director Michael Duffy taking over duties related to apportionments of USAI FMF from Deputy Associate Director Mark Sandy or any other Office of Management and Budget employee. D, all meetings related to the security assistance to Ukraine, including but not limited to interagency meetings on July 18th, 2019, July 23rd, 2019, July 26th, 2019, and July 31st, 2019, including any directions provided to staff participating in those meetings and any readouts from those meetings. E, the decision announced on or about September 11, 2019 to release appropriated foreign assistance, military assistance, or security assistance to Ukraine, including but not limited to any notes, memoranda, documentation, or correspondence related to the
This is the
decision.
next amendment. Obviously, that
All
must
draft
have
and
not
final
passed the
versions
other
of
amendment.
talking points related to the withholding or release
Otherwise,
of
they wouldn't
foreign
be reading
assistance, military
third one.
assistance, or security assistance to Ukraine, including
My guess is it
communications
was
with the
also
Department of Defense
5347
related to
along.
concerns about the accuracy
party
of the
lines.
talking points. And G, all meetings and calls between President Trump and the President of Ukraine, including documents, communications, and other records related to the scheduling of, preparation for, and follow-up from the President's April 21st and July 25th, 2019 telephone calls, as well as the President's September 25th, 2019 meeting with the President of Ukraine in New York. And 2, the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice,
The majority leader is recognized.
first, a scheduling note, as the parties are ready to debate this amendment, I suggest we go ahead, get through the debate, and vote before we take a 30-minute recess for dinner. And I would remind everyone that I'll be moving to table the amendment, and it's also important to remember that both evidence and witnesses are addressed in the underlying resolution.
Thank you. The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent or opponent of the motion? Proponent. Mr. Cipollone, are you a proponent or opponent? Then Mr. Schiff, your side will proceed first, and you will be able to reserve time for rebuttal. Thank you.
Before I begin, Mr. Chief Justice, the House managers will reserve the balance of our time to respond to the counsel for the president. Mr. Chief Justice, Senators, counsel for the president and the American people. I am Jason Crow from the great state of Colorado. The House managers strongly support this amendment to subpoena key documents from the Office of Management and Budget, or OMB. These documents go directly to one of President Trump's abuses of power. His decision to withhold vital military aid from a strategic partner that's at war to benefit his own personal re-election campaign. But why should that matter? Why should anybody care? Why should I care? Before I was a member of Congress, I was an American soldier serving in Iraq and Afghanistan. And although some years have passed since that time, there are still some memories that are seared in my brain. One of those memories was scavenging scrap metal on the streets of Baghdad in the summer of 2003 that we had to bolt onto the side of our trucks because we had no armor to protect against roadside bombs. So when we talk about troops not getting the equipment that they need when they need it, it's personal to me. To be clear, here we are talking of $391 million of taxpayer money intended to protect our national security by helping our strategic partner, Ukraine, fight against Vladimir Putin's Russia, an adversary of the United States. But the president could not carry out this scheme alone. He needed a lot of people to help him. And that's why we know as much about it as we do today. But there is much more to know. And that's what trials are for, to get the full picture. We know there's more because President Trump needed the Office of Management and Budget to figure out how to stop what should have been a routine release of funds mandated by Congress. a release of funds that was already underway. But the people in this chamber don't need me to tell you that, because 87 of you in this room voted for those vital funds to support our partner, Ukraine. Witnesses before the House testified extensively about OMB's involvement in carrying out the hold. It was OMB that relayed the president's instructions and implemented the hold. And it was OMB that scrambled to justify the freeze. OMB has key documents that President Trump has refused to turn over to Congress. It is time to subpoena those documents. These documents would provide insight into critical aspects of the military aid hold. They would show the decision-making process and motivations behind President Trump's freeze. They would reveal the concerns expressed by career OMB officials, including lawyers, that the hold was violating the law. They would expose the lengths to which OMB went to justify the president's hold. They would reveal concerns about the impact of the freeze on Ukraine and US national security. And they would show that senior officials repeatedly attempted to convince President Trump to release the hold. In short, they would show exactly how the president carried out the scheme to use our national defense funds to benefit his personal political campaign. We are not speculating about the existence of these documents. We are not guessing what the documents might show. During the course of the investigation in the House, witnesses who testified before the committees identified multiple documents directly relevant to the impeachment inquiry that OMB continues to hold to this day. We know these documents exist, and we know that the only reason we do not have them is because the president directed OMB not to produce them, because he knows what they would show. To demonstrate the significance of the OMB documents and the value they would provide in this trial, I would like to walk you through some of what we know exists, but which the Trump administration has refused to turn over. As we have discussed, the Trump administration has refused to turn over any documents to the House in response to multiple subpoenas and requests. Based on what is known from the testimony and the few documents that have been obtained through public reporting and lawsuits, it's clear that the president is trying to hide this evidence because he is afraid of what it would show. The documents offer stark examples of the chaos and confusion that the president's scheme set off across our government. And they make clear the importance of the documents that are still being concealed by the president. We know that OMB has documents that reveal that as early as June, the president was considering holding military aid for Ukraine. The president began questioning military aid to Ukraine after Congress appropriated and authorized the money. $250 million in DoD funds and $141 million in State Department funds. This funding had wide bipartisan support because, as many witnesses testified, providing military aid to Ukraine to defend itself against Russian aggression also benefits our own national security. Importantly, the president's questions came weeks after the Department of Defense already certified that Ukraine had undertaken the anti-corruption reforms and other measures mandated by Congress as a condition for receiving that aid. So there is a process for making sure that the funds make it to the right place and to the right people. A process that has been followed every year that we have been providing that security assistance to Ukraine, including the first 2 years under the Trump administration. Nonetheless, the president's questions came days after DoD issued a press release on June 18th, announcing it would provide its $250 million portion of the taxpayer-funded military aid to Ukraine. According to public reporting, The day after DOD's press release, a White House official named Robert Blair called OMB's acting director, Russell Vought, to talk about the military aid to Ukraine. According to public reports, Mr. Blair told Vought, quote, "We need to hold it up." OMB has refused to produce any documents related to this conversation. The Senate can get them by passing the amendment and issuing a subpoena. But there's more. The same day Blair told Vought to hold up the aid, Michael Duffy, a political appointee at OMB who reports to Vought, emailed Deputy Undersecretary of Defense Elaine McCusker and told her that the president had questions about the aid. Duffy copied Mark Sandy, a career official at OMB, who told us about the email in his testimony before the House. Like all others, that email was not produced by the Trump administration in the House impeachment investigation. We know this email exists, however, because in response to a Freedom of Information Act lawsuit, the Trump administration was forced to release a redacted email consistent with Sandy's description. But OMB provided none of those documents to the House. With this proposed amendment, the Senate has an opportunity to obtain and review the full record that could further demonstrate how and why the president was holding the aid.
Right.
These documents would also shed light on the president's order to implement the hold. On July 3rd, the State Department told various officials that OMB blocked it from dispensing $141 million in aid. OMB had directed the State Department not to send a notification to Congress about spending the money. And without that notification, the aid was effectively blocked. Why did OMB block the congressional notification? Who told them to do it? What was the reason? The Senate would get those answers if it issued this subpoena. But there's more. On July 12th, Blair, the White House official who had called Vought on June 19th and said, quote, "We need to hold it up," then sent an email to Duffy at OMB. Blair said, quote, "The president is directing a hold on military support funding for Ukraine." We haven't seen this email. The only reason we know about it is from the testimony of Mark Sandy, the career OMB official who followed the law and complied with his subpoena. As you can see from the transcript excerpt in front of you, Sandy testified that the July 12th email did not mention concerns about any other country or any other aid packages, just Ukraine. So of the dozens of countries where we provide aid and support, the president is only concerned about one of them, Ukraine. Why? Well, we know why. But OMB has still refused to provide a copy of this July 12 email and has refused to provide any documents surrounding it, all because the president told OMB to continue to hide the truth from Congress and the American people. What was he afraid of? A subpoena issued by the Senate would show us. OMB also has documents about a key series of meetings triggered by the president's order to hold the military aid. In the second half of July, the National Security Council convened a series of interagency meetings about the president's hold on military aid. OMB documents would show what happened during those meetings. For example, on July 18th, the National Security Council staff convened a routine interagency meeting to discuss Ukraine policy. During the meeting, it was the OMB representative who announced that President Trump placed a hold on all military aid to Ukraine. Ambassador Bill Taylor, our most senior diplomat to Ukraine, participated in that meeting. And he described his reaction at his open hearing.
In a regular NSC secure video conference call on July 18th, I heard a staff person from the Office of Management and Budget say that there was a hold on security assistance to Ukraine, but could not say why. For the end of an otherwise normal meeting, a voice on the call, the person was off screen, said that she was from OMB and her boss had instructed her not to approve any additional spending on security assistance for Ukraine until further notice. I and others sat in astonishment. Ukrainians were fighting Russians and counted on not only the training and weapons, but also the assurance of US support. All that the OMB staff person said was that the directive had come from the president to the chief of staff to OMB. In an instant, I realized that one of the key pillars of our strong support for Ukraine was threatened.
It's hard to believe that OMB would not have any documents following this bombshell announcement. It surely does. It was the agency that delivered the shocking news to the rest of the US government that the president was withholding the vital military aid from our partner. And we would see these documents if the Senate issued a subpoena. The July 18th meeting was just the first in a series of meetings where OMB held the line and enforced the president's hold on the aid. But there was a second meeting on July 23rd, where we understood agencies raised concerns about the legality of OMB's hold on the aid. And then a third meeting at a more senior level on July 26th. Witnesses testified that at that meeting, OMB struggled to offer an explanation for the president's hold on the aid. And then a fourth meeting on July 31st, where the legal concerns about the hold were raised. At each of these meetings, there was confusion about the scope and the reasons for the hold. Nobody seemed to know what was going on. But that was exactly the point. All of the agencies, except OMB, which was simply conveying the president's order, supported the military aid and argued for lifting the hold. OMB did not produce a single document providing information about its participation, preparation, or follow-up from any of these meetings. Did these OMB officials come prepared with talking points for these meetings? Did OMB officials take notes during any of these meetings? Did they exchange emails about what was going on? Did OMB discuss what reasons they could give everyone else for the hold? By issuing this subpoena, the Senate can find out the answers to all of those questions and others like them. The American people deserve answers. OMB documents would also reveal key facts about what happened on July 25th. On July 25th, President Trump conducted his phone call with President Zelensky, during which he demanded a favor. This favor was for Ukraine to conduct an investigation to benefit the president's re-election campaign. That call was at 9 a.m. Just 90 minutes after President Trump hung up the phone, Duffy, the political appointee at OMB, who is in charge of national security programs, emailed DOD to, quote, formalize, end quote, the hold on the military aid. Just 90 minutes after President Trump's call, a call in which the president had asked for a favor. That email is on the screen in front of you. We have a redacted copy of this email because it was recently released through the Freedom of Information Act. It was not released by the Trump administration in response to the House's subpoena. In this email, Duffy told the DOD officials that based on the guidance he had received, they should, quote, hold off on any additional DOD obligations of these funds. He added that the request was, quote, sensitive, and that they should keep this information closely held, meaning don't tell anybody about it. Why did Duffy consider the information sensitive? Why didn't he want anyone to learn about it? Answers to those questions may be found in OMB emails that we could all see if you issue a subpoena. But there's more. Remember, the administration needed to create a way to stop funding that was already underway. The train had already left the station. And something like this had never been done before. Later in the evening of July 25th, OMB found a way. Even though DOD had already notified Congress that the funds would be released. Here is how the scheme worked. OMB sent DOD a funding document that included a carefully worded footnote directing DOD to hold off on spending the funds. Quote, to allow for an interagency process to determine the best use, end quote. Remember that language. To allow for an interagency process to determine the best use. Let me explain that. The footnote stated that this, quote, brief pause would not prevent DOD from spending the money by the end of the fiscal year, which was coming up on September 30th. OMB had to do this because it knew that not spending the money was illegal. And they knew that DOD would be worried about that. And they were right. DOD was worried about it. Mr. Sandy testified that in his 12 years of experience at OMB, he could not recall anything like this ever happening before. The drafting of this unusual funding document and the issuance of the document must have generated a significant amount of email traffic, memos, and other documentation at OMB. Memos, email traffic, and documentation that we would all see if the Senate issued a subpoena. So what was the result from the series of events on July 25th? Where was Mr. Duffy's guidance to implement the hold coming from? Why was the request sensitive? What was the connection between OMB's direction to DOD and the call President Trump had with President Zelensky just 90 minutes before? Did agency officials communicate about the questions coming from Ukrainian officials? The American people deserve answers. A subpoena would provide those answers. OMB documents also would reveal information about the decision to have a political appointee take over Ukraine funding responsibility. The tensions and chaos surrounding the freeze escalated at the end of July when Duffy, a political appointee at OMB, with no relevant experience in funding approvals, took authority for releasing military aid to Ukraine away from Sandy, a career OMB official. Sandy could think of no other example of a political appointee taking on this responsibility. Sandy was given no reason other than that Mr. Duffy wanted to be, quote, more involved in daily operations, end quote. During his deposition, Sandy confirmed that he was removed from the funding approval process after he had raised concerns to Duffy about whether the hold was legal under the Impoundment Control Act. Needless to say, OMB has refused to turn over any documents or communications involving that decision to replace Mr. Sandy. Why did Duffy, a political appointee with no relevant experience in this area, take over responsibility for Ukraine funding approval? Was the White House involved in that decision? Was Sandy removed because he had expressed concerns about the legality of the hold? By August 7th, people in our government were worried. And when people in the government get worried, sometimes what they do is they draft memos. Because when they're concerned about getting caught up in something that doesn't seem right, they don't want to be a part of it. So on that day, Mark Sandy and other colleagues at OMB drafted and sent a memo about Ukraine military aid to Acting Director Vaught. According to Sandy, the memo advocated for the release of the funds. It said that the military aid was consistent with American national security interests. It would help to oppose Russian aggression, and it was backed by strong bipartisan support. But President Trump did not lift the hold. Over the next several weeks, OMB continued to issue funding documents that kept kicking the can down the road, supposedly to allow for more of this, quote, interagency process. While inserting those footnotes throughout the apportionment documents stating that the delay wouldn't affect the funding. But here's the really shocking part. There was no interagency process. They made it up. It had ended months before. They made it up because nobody could say the real reason for the hold. In total, OMB issued 9 of these documents between July 25th and September 10th. Did the White House respond to OMB's concerns and recommendation to release the aid? Did the White House instruct OMB to continue creating a paper trail in an effort to justify the hold? Who knew what and when? OMB documents would shed light on OMB's actions as the president's scheme unraveled. Did the White House direct OMB to continue issuing the hold? What was OMB told about the president's reasons for releasing the hold? What communications did OMB officials have with the White House around the time of the release? As the president's scheme unraveled, did anyone at OMB connect the dots about the real reason for the hold? The OMB documents would shed light on all of these questions, and the American people deserve answers. I remember what it feels like to not have the equipment you need when you need it. Real people's lives are at stake. That's why this matters. We need this information so we can ensure that this never happens again. Eventually, this will all come out. We will have answers to these questions. The question now is whether we'll have them in time and who here will be on the right side of history.
Sekulow?
Mr. Chief Justice, the House managers reserve the balance of our time for an opportunity to respond to the president's argument.
Thank you. Mr. Sekulow?
Thank you, Mr. Chief Justice, members of the Senate. Manager Crow, you should be happy to know that the aid that was provided to Ukraine over the course of the president's administration included lethal weapons. Those were not provided by the previous administration. The suggestion that the Ukraine failed to get any equipment is false. The security assistance was not for funding Ukraine over the summer of 2019. There was no lack of equipment due to the temporary pause. It was future funding. The Ukraine Deputy Minister of Defense, who oversaw U.S. aid shipments, said the hold came and went so quickly, they did not notice any change. Undersecretary of State David Hale explained the paused aid was future assistance, not to keep the Army going now. So the made-up narrative that security assistance was conditioned on Ukraine taking some action on investigations is further disproved by the straightforward fact that the aid was delivered on September 11th, 2019, without Ukraine taking any action on any investigation. It's interesting to note that the Obama administration withheld $585 million of promised aid to Egypt in 2013. But the administration's public message was that the money was not officially on hold, as technically it was not due until September 30th, the end of the fiscal year. So they didn't have to disclose the halt to anyone. Sounds like this may be a practice of a number of administrations. In fact, to the president, this president has been concerned about how aid is being put forward. So there have been pauses on foreign aid in a variety of contexts. In September of 2019, the administration announced that it was withholding over $100 million in aid to Afghanistan over concerns about government corruption. In August of 2019, President Trump announced that the administration and Seoul were in talks to substantially increase South Korea's share of the expense of U.S. military support for South Korea. In June, President Trump paused over $500 $50 million in foreign aid to El Salvador, Honduras, and Guatemala because those countries were not fairly sharing the burdens of preventing mass migration to the United States. This is not the only administration. As I said, President Obama withheld hundreds of millions of dollars of aid to Egypt. To be clear, and I want to be clear, Ambassador Yovanovitch herself testified that our policy actually got stronger under President Trump, largely because, unlike the Obama administration, quote, this administration made the decision to provide lethal weapons to Ukraine to help Ukraine fend off Russian aggression. She testified in a deposition before your various committees that, and actually I felt that in the 3 years that I was there, partly because of my efforts, but also the interagency team and President Trump's decision to provide lethal weapons to Ukraine, that our policy actually got stronger. Deputy Assistant Secretary Kent, names come up a couple of times, agreed that javelins are incredibly effective weapons at stopping armored advance, and the Russians are scared of them. Ambassador Volker explained that President Trump approved each of the decisions made along the way, and as a result, America's policy towards Ukraine strengthened. So when we want to talk about facts, go to your own discovery and your own witnesses that you called. This all supposedly started because of a whistleblower. Where is that whistleblower?
The House managers have 35 minutes remaining.
Mr. Chief Justice, at war, time matters. Minutes and hours can seem like years. So the idea that, well, it made it there eventually just doesn't work. And yes, the aid was provided. It was provided by Congress, this Senate, in the House of Representatives with the president's signature. The Congress is the one that sends the aid. And millions of dollars of this aid would have been lost because of the delay had Congress not actually passed another law that extended that deadline to allow the funds to be spent. Let me repeat that. The delay had jeopardized the expenditure of the money to such an extent that Congress had to pass another law to extend the deadline so that the money and the equipment got to the people on the front lines. Need I also reiterate the supposed interagency process, the concerns that the president and his council continue to raise about corruption and making sure that the process went right. There was no interagency process. The whole thing was made up. It was a phantom. There was a delay, and delays matter. Mr. Chief Justice, I reserve the balance of my time for Mr. Schiff.
Mr. Schiff?
Thank you, Mr. Chief Justice. Just a few additional points I'd like to make on this amendment and on my colleagues' arguments. First of all, Mr. Sekulow makes the point that the aid ultimately got released. They ultimately got the money, right? Yes, they got the money after the president got caught, after the president was forced to relieve the hold on the aid, after he got caught, yes. But even then they had held on to the aid so long that it took a subsequent act of Congress to make sure it could all go out the door. So what, is the president supposed to get credit for that? That we had to intervene because he withheld the aid so long? And that's the only reason Ukraine got all of the aid that we'd approved in the first place? My colleagues have glossed over the fact that what they did was illegal, that the GAO, an independent watchdog agency, found that that hold was illegal. So it not only violated the law, it not only took an act of Congress to make sure they ultimately got the aid. This is supposed to be the defense to why you shouldn't see the documents? Is that what we're to believe? Now, counsel also says, well, you know, he's not the first president to withhold aid. And that's true. After all, counsel says, well, President Obama withheld aid to Egypt. Yes, at the urging of members of Congress. Senators McCain and Graham urged that that aid be withheld. And why? Because there was a revolution in Egypt after it was appropriated. That wasn't something that was hidden from Congress. That was a pretty darn good reason to think that we still want to give aid to this government after this revolution. We're not saying that aid has never been withheld. That's absurd. But I would hope and expect this is the first time aid has been withheld by a president of the United States to coerce an ally at war to help him cheat in the next election. I think that's a first. But what we do here may determine whether it's the last. And one other thing about this pause in aid, right? The argument, well, no harm, no foul. Okay, you got caught, they got the aid. What's the big deal? Well, as we heard during the trial, it's not just the aid. I mean, the aid is obviously the most important thing. As Mr. Crow mentioned, you know, without it, you can't defend yourself, and we'll have testimony about just what kind of military aid the president was withholding. But we also had testimony that it was the fact of the aid itself that was so important to Ukraine, the fact that the United States had Ukraine's back. And why? Because this new president of Ukraine, this new untested former comedian, president of Ukraine, at war with Russia, was going to be going into a negotiation with Vladimir Putin with an eye to ending that conflict. And whether he went into that negotiation from a position of strength or a position of weakness would depend on whether we had his back. And so when the Ukrainians learned and the Russians learned that the president of the United States did not have his back, was withholding this aid, what message do you think that sent to Vladimir Putin? What message do you think it sent to Vladimir Putin when Donald Trump wouldn't let Vladimir Zelensky, our ally, in the door of the White House, but would let the Russian foreign minister? What message does that send? So it's not just the aid, it's not just when the aid is delivered, it's not just if all of the aid is delivered, it's also what message does the freeze send to our friend, and even more importantly, to our foe. And the message it sent was a disaster. Was a disaster. Now, you might ask yourself, because counsel has said, hey, President Trump has given lethal weapons to Ukraine. You might ask yourself, if the president was so concerned about corruption, why did he do that in 2017? And why did he do that in 2018? Why was it only 2019 that there was a problem? Was there no corruption in Ukraine in 2017? Was there no corruption in Ukraine in 2018? No. Ukraine has always battled corruption. It wasn't the presence or lack of corruption in one year to another. It was the presence of Joe Biden as a potential candidate for president. That was the key change in 2019. That made all the difference. Let's gets back to one of the key moments in this saga. You know, a lot of you are attorneys. You're probably much better attorneys than I am. And I'm sure you had the experience in cases you tried where there was some vignette, some conversation, some document. It may not have been the most important on its face, but it told you something about the case that was much larger than that conversation. For me, one of those conversations was not on July 25th between President Trump and President Zelensky, but on July 26th, the very next day. Now, you may have watched some of the House proceedings, or you may haven't, and people watching may have seen it, maybe they didn't. But there's this scene in a Ukrainian restaurant, a restaurant in Kyiv, with Gordon Sondland. Now, bear in mind, Gordon Sondland, who said there was absolutely a quid pro quo and 2 + 2 = 4, this is not some never Trumper. This is a $1 million donor to the Trump inauguration, okay? If there's a bias there, it's clearly a $1 million bias in favor of this president, not against him. So there's a scene in Kyiv, in this restaurant, and Sondland has a cell phone, and he's sitting with David Holmes, who's a career diplomat, US diplomat in the Ukraine embassy. And Gordon Sondland takes out his phone and he calls the White House. Gordon Sondland holding for the White House, Gordon Sondland holding for the president. And it takes a while to be connected, but he's connected to the president. That's pretty impressive, right? This isn't some guy with no relationship to the president. The president may say, Gordon Sondland, I barely know him, or something to that effect, but this is a guy who can pick up a cell phone. He can call the president of the United States from a restaurant in Kyiv, and he does. And the president's voice is so loud that David Holmes, this diplomat, can hear it. And what does the president say? Does he say, how's that reform coming in the Rada? How's the attack on corruption going? No. He just says, is he going to do the investigation? Is Zelensky going to do the investigation? And Sondland says, yes, he'll do anything you want. He loves your ass. This is the extent of the president's interest in Ukraine. And they go on to talk about other things. And then they hang up. And David Holmes turns to the ambassador and says, in language which I will have to modify to remove an expletive, says something along the lines of, does the president give a blank about Ukraine? And Sondland says, no, he doesn't give a blank about Ukraine. He only cares about the big stuff, like the investigation of the Bidens that Giuliani wants. This is $1 million donor to the Trump inaugural, admitting the president doesn't care about Ukraine. He doesn't care whether they get military dollars to defend themselves. He doesn't care about what position Zelensky goes into in these negotiations with Putin. He doesn't care about that. Isn't that clear? It's why he didn't care about corruption in 2017 or 2018, and he certainly didn't care about it in 2019. All he cared about was the big stuff that affected him personally, like this investigation that he wanted of the Bidens. So when you ask, do you want to see these documents? Do you want to know if these documents corroborate Ambassador Sondland? Will the documents show, as we fully expect they will, that the only thing he cared about was the big stuff that affected him? David Holmes' response was, well, you know, there's some big stuff going on here, like a war with Russia. This isn't withholding aid because of a revolution in Egypt. This is withholding aid from a country in which 15,000 people have died fighting the Russians. And as Ambassador Taylor said, and others, you know, Russia's fighting to remake the map of Europe by dint of military force. If we think that's just about Ukraine's security, we are very deceived. It's about our security. It's about the tens of thousands of troops that we have in Europe. And if we undercut our own ally, if we give Russia reason to believe we will not have their back, that we'll use Ukraine as a plaything, or worse, to get them to help us cheat in an election, that will only embolden Putin to do more. You said it as often as I have. The only thing he respects is strength. Do you think that looks like strength to Vladimir Putin? I think that looks like something that Vladimir Putin is only too accustomed to. And that is the kind of corruption that he finds and he perpetuates in his own regime and he pushes all around the world. My colleague Val Demings made reference to a conversation, which I think is one of the other key vignettes in this whole sad saga. And that's a conversation that Ambassador Volker has with Andrei Yermak, one of the top aides to President Zelensky. And this is a conversation in which Ambassador Volker is doing exactly what he's supposed to be doing, which is he's telling Yermak, you know, you guys shouldn't really do this investigation of your former President Poroshenko because it would be for a political reason. You really shouldn't engage in political investigations. And as Representative Deming said, what's the response from Ukrainians? Oh, you mean like the one you want us to do of the Bidens and the Clintons? Threw it right back in his face. Ukraine's not oblivious to that hypocrisy. Mr. Seklo says, what are we here for? You know, part of our strength is not only our support for our allies, it's not only our military might, it's what we stand for. We used to stand for the rule of law. We used to champion the rule of law around the world. Part of the rule of law is, of course, that no one is above the law. But to be out in Ukraine or anywhere else in the world championing the rule of law and saying, don't engage in political prosecutions, and having them throw it right back in our face, oh, you mean like the one you want us to do? That's why we're here. That's why we're here. That's why we're here. I yield back.
Mr. Chief Justice,
Majority Leader is recognized.
I send a motion to the desk to table the amendment and ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines.
Well, after this vote, we will also be
Duckworth.
concluding our coverage here at Vote Count 2020.
Mr.
I am
Durbin.
Karthik Rajan,
Mr. Enzi.
and I'll be back hopefully tomorrow with more
Yes,
coverage
sir.
of the Senate
Mrs.
impeachment
Feinstein.
trial.
Mrs. Fisher. Mr. Gardner.
Of the 45th President of the United States of
Mrs.
America,
Gillibrand.
Donald J. Trump.
Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee, Mrs. Leffler, Mr. Manchin, Mr. Markey, Mr. McConnell, Ms. McSally, Mr. Menendez, Mr. Merkley, Mr. Moran, Ms. Murkowski, Mr. Murphy, Mrs. Murray, Mr. Paul, Mr. Purdue, Mr. Peters, Mr. Portman, Mr. Reed, Mr. Rich, Mr. Roberts, Mr. Romney, Ms. Rosen, Mr. Rounds, Mr. Rubio, Mr. Sanders, Mr. Sass, Mr. Schatz, Mr. Schumer, Mr. Scott of Florida, Mr. Scott of South Carolina, Mrs. Shaheen, Mr. Shelby, Ms. Sinema, Ms. Smith, Ms. Stabenow, Mr. Sullivan, Mr. Tester, Mr. Thune, Mr. Tillis, Mr. Toomey, Mr. Udall, Mr. Van Hollen, Mr. Warner, Ms. Warren, Mr. Whitehouse, Mr. Wicker, Mr. Wyden, Mr. Young.
So there you have it, the vote on the second or third rather of the amendments proposed by Mr. Schumer of New York, the Democrat. The first two were rejected. They were tabled. And that was the vote here for the third amendment. We're going to see if the count is in fact similar to the previous along partisan lines, exactly 53 to 47. Or if, as these get read, some Republicans choose to hear more and expand how the impeachment will be done, which has been set by Mr. McConnell, the ranking member from Kentucky. The Senate impeachment trial has been going on today.
The yeas are 53, the nays are 47.
Exactly the same.
The motion is tabled.
It's probably going to do it, folks, for us.
The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to issue a subpoena to John Michael Mick Mulvaney, and I ask that it be read.
Clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1287. At the appropriate place in the resolving clause, insert the following section: notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena for the taking of testimony of John Michael Mick Mulvaney, and the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
Mr. Chief Justice,
The majority leader is recognized.
I now ask for a 30-minute recess before the parties are recognized to debate the Schumer amendment. Following the debate time, I will once again move to table the amendment because votes on witnesses and evidence, as I've repeatedly said, are addressed in the underlying resolution. So I ask that the Senate stand in recess until 8 p.m.
Without objection, so ordered. To bang the gavel, right?
So there you have it. As they go to recess, I will
Live
too.
from the U.S.
And,
Senate and a live view of the Capitol from the Russell Senate Office Building as the Senate stands in recess for what is scheduled to be a half-hour break. But as typical with these breaks, it could last just a little bit longer. We will use this opportunity to update you on where things stand. A reminder that Senate Democrats putting forth 3 measures to try to have more evidence in the trial. And here's what happened. First of all, in subpoenaed White House documents, that was tabled by a party line vote of 53 to 47. Also to subpoena those State Department documents, again, a party line vote, 53 to 47. And just a moment ago, the White House Budget Office documents. And so that is where things stand right now. Our phone lines are open. We want to hear from you. You can also send us a text message
that's all right.
at 202-748-8003. The senators leaving the Senate chambers, heading to their respective offices for a dinner break. It's to be Senate Republican leader Mitch McConnell. We're going to show you the scene outside the Senate chambers. Get to your phone calls. 202 is the area code here in Washington, D.C., and we'll get to your calls in just a moment. Again, the text message is 202-748-8003. For Democrats, 748.
Okay, we're going to go ahead and take a break time from their coverage in order to wrap up our own. This has been Vote Count 2020. I am Karthik Rajan, and in our ongoing coverage of the impeachment trial of Donald John Trump in the Senate, we will be picking this up tomorrow, Wednesday, the 22nd of January. I hope you will join us for this historic and important event.